Wonderful. Today we're talking about everybody's favorite subject, which of course is not the case because it's probably one of the least favorite subjects that real estate agents have. And it has to do with the transfer disclosure statement, the seller property questionnaire, and the AVID. Right? And so I've put a lot of stuff in this folder. We're not going to necessarily go through it line by line, but I put a lot of stuff in the folder. And what I want to do is, if you're very analytical, you'll like the long articles. If you're not very analytical, you'll like the quick guides. But what I want to do is to go through how you would, first of all, get a seller to sign a transfer disclosure statement and complete it. That's our first goal, right? First goal. Then, and what kind of advice and suggestions should you be giving to the seller in that process? That's the first one. Number two is going to be the question of what do you do? All right, now that you've got the seller to fill out the SPQ or the TDS, what do you do when you do your AVID, or do you not need to do the AVID, that sort of thing. And we're going to start, I've created a transaction, right? I created a transaction. And I don't know if I've added everything to it yet. Seller property questionnaire is there. Transfer disclosure statement. So you need to learn how to use zip forms, also known as lone wolf technologies, right? And so you guys I know can talk because I've, set it up so that you can if you want to. And I just want to show you what agents fill out, and then I'm going to send it to myself, and then we're going to go through what a seller is going to see. Right? Does that sound like fun? Aren't you guys just happy? It sounds like fun, doesn't it? Now, one of the things you may notice, and I help lots of agents do their first transactions, God forbid, and so one of the things that people don't seem to understand, by people I mean real estate agents, is that all those little yellow boxes are places where you can write. Right? And the boxes that are grayed out are
Michael, can you share your screen?
Oh, sorry about that. Thank you for mentioning that. It's been one of those days. All right, how about that?
Thank you.
I appreciate that. This is what happens with multitasking. All right, so I created a sample transaction. We're going to open up a transfer disclosure statement. We're going to go through how to fill it out. So everything that is in yellow is something that you could fill out. If it's not in yellow, and I know it looks orange on some browsers, but if it's not, that means you cannot fill it out. So if you're doing this, you are, what this means is you as the real estate agent can't go in and check all the boxes for the seller and send it to them so they just sign it. You understand what I'm saying? Right? Not only is that a violation of the civil code and a bunch of other things, but the software is not designed so that you can do that, right? It's designed to prevent you from filling it out. You're not supposed to fill out the seller's portion. Now, having said that, I've actually seen people say this, by people I mean brokers, and what they'll say is, I'll put this down here. What they'll say is that you shouldn't say anything to the seller. I've heard a broker say this. And if they have any questions about any of these things, tell them to call a lawyer. I don't know. So most of the time, I'm answering the seller's questions about the SPQ and the TDS. I'm just saying, and I'm not telling them how to fill it out, but they'll ask me, well, what does this mean? And you might have to explain what it means, right? You might have to explain what it means. So what can we fill out? Well, in my make-believe, this will be in the city of San Jose. And let me see, I'm seeing chat. It's hard for me to see the chat when I'm in a share the screen mode. So if you're chatting something and you want an answer, say it aloud if you can. Otherwise, you're going to have to wait a while before I can get to it. County of Santa Clara, and described as, let's just say, 123 Greenwood Drive, San Jose, California. And no, that's not a real street. And let's say we're doing it today. So I would probably be discussing with the seller about I'll be chatting with the seller. So let's say I'm on a listing appointment and they've signed the listing, everything is good. I usually send the seller disclosures in 2 packages. The first thing I'm going to send the seller is the TDS and the SPQ. And the way I explain this to the seller is these are the only 2 of the disclosures that are really going to require any thought on your part. Right? Almost everything else that a seller is going to fill out, and we're going to go through all those forms too, but everything else is essentially a warning to the buyer. It's an advisory. All right, so the statement is a disclosure of the condition of the above described property in compliance with Section 1102 of the Civil Code as of, right? What day are they going to be filling it out? It is not a warranty of any kind by sellers or agents representing any principals, and then coordination with other disclosure forms. Now, this is sort of an annoying thing, but let's just talk about, let me ask you guys this, and it would be helpful if you would, if you could speak your answer or chat it in. I can, let's say your client's an investor who bought the property last year from the bank. It's an REO, right? That, for those of you who don't know, stands for Real Estate Owned by the Bank. And REO, you don't get any disclosures, right? You don't get anything if you buy something from the bank. So the investor has fixed the property up and is flipping it. The investor has never lived in the property. This is my question. Does the investor have to fill out a transfer disclosure statement? Never lived in the property, right? Can they just maybe give you a property inspection? Can they skip it because they've never lived in the property? Do they have to fill it out just like everybody else? What's the answer to that?
The answer was no, because they never lived there.
The answer is no, they don't have to fill it out because they never lived there. Great. I'm glad that at least one person saw this as the audience participation part. Any other answers?
I still have to fill it out.
They still have to fill it out. Well, we have 2 diverging opinions here.
I thought there was an additional one. There was a separate one if they haven't lived there, right?
There is something called the seller statutory disclosures, but those are for exempt, and they're not. So one of the documents that I should have put here, let me see, seller promise, substituted, transfer, visual inspection. It may not have uploaded yet. So I'm just going to say it. The transfer disclosure statement is required in all residential sales of 1 to 4 units unless it's a bank-owned property, an REO, a successor trust transaction, that these are exempt ones, a bankruptcy transaction, or a probate transaction. Now, the list is a bit longer than that, but that's pretty much what it is. Is this the one? How about this? Transfer disclosure statement exemptions. I'll rename that. I knew I had included it someplace. So I'll rename that just to make it a little bit easier. How about that? All right. So, exemptions. There aren't very many. So there's some links here which would work. And are there? Here they are. A public report means a subdivision. Court-ordered probate sales, bankruptcy trustees, writ of execution, eminent domain, foreclosure sales, a fiduciary in the administration of decedent's estate, like a conservatorship, transfers of one co-owner to another one, transfers made to parent or child between spouses, state controller, failure to pay property taxes to or from any other government entities. Now, what you'll notice that is not on that list is I'm an investor and I never really lived there, so I don't have to fill it out. You'll notice that's not on the list. Right? Not on, and I've actually had clients say, I'm not going to fill it out. I've never lived there. You guys are just trying to trick me into answering questions so you can sue me later. I'm going to fall for it. Now, I've actually said to them, because I'm kind of snarky and sarcastic, that I checked prior to our meeting and I reread the California Civil Code section, and I noticed that their name is not mentioned as an exemption to the rules. I just noticed that, right? I looked to see if your name is there and your name isn't there, right? And then I've still had people say, I'm going to do it. So what would you do if your client is not on this list and just says, I'm not going to do it? What should you do?
You haven't signed some kind of a waiver?
They aren't going to do that. I ain't going to sign a waiver.
You fill out an addendum explaining the situation?
Fill out an addendum. Those are all nice things, but sometimes they won't do that. Now, I have gotten them sometimes.
Send an email.
Send them an email, right? And the E stands for?
Evidence.
Evidence. Very good.
Evidence.
Right, evidence. Sometimes I have written in a statement that says seller refuses to fill it out, and because they've never lived there and they've initialed it. But what else would you do? What's the most important thing for you to do if the seller will not fill out the TDS?
Inform the broker and the escrow.
Inform broker. Escrow doesn't care. Escrow doesn't get a copy of the TDS. The broker isn't going to like it. So I'll jump in with what I think would be a good answer. Fill out your disclosure form. We can't control the sellers, right? If you think you can control sellers, you haven't had that many listings, right? You know, because we can't make them do it. Right now, at EXP, and this is true for other large companies, they use software. We use SkySlope. And one of the things you're supposed to have is this document, or you could upload an email where the person says, I'm going to do it. And he's, all right, fine. So if they're not, there are very few exemptions. Let me get back to my transaction. Very few exemptions. That's not one of them. Now, look at substituted disclosures. See, I really haven't even thought about this subject, and I was hoping you guys could sort of drag me through the form. It says coordination with other disclosure forms. All right. Maybe that's an important paragraph. It says the transfer disclosure statement is made pursuant to 1102 of the Civil Code. Other statutes require disclosures depending upon the details of the particular transaction. Special study zone, purchase money, liens on residential property. Substituted disclosures. The following disclosures and other disclosures required by law, including the natural hazard disclosure report statement that may include airport, have or will be made in connection with this real estate transfer and are intended to satisfy the disclosure obligations on this form where the subject matter is the same. All right, cool. So if I already have inspections and disclosures, should I mark that and put them in here? Let's say we've got a termite report, we have a property inspection, we have a roof inspection, we have a chimney inspection, right? We have a pool inspection, right? We have an inspection. Do I list them, cram all those in here and list them here under additional inspection reports or disclosures? Is that what I should do? List them if I got them? Yes?
If you have them, they should be listed.
They should be. All right. Inspection reports pursuant to the contractor sale or receipt or deposit, maybe. So those of you that are older, more experienced, and have, no social life, and so you remember stuff like this, the third choice, no substituted disclosures for this transfer. You see that? That part there? That was added in. And one of the documents that I have shared in my little folder, it has to do with substituted disclosures. Now, what you're going to find if you read this is that when they originally wrote the transfer disclosure law, they being the people, the politicians, right, that passed the law, and the people that designed the original law, they had in their mind that maybe at some point in time there would be a substitute for the seller filling out the form, and that a certain type of inspection or something like that. Now, what's happened is none of that's ever come to pass, right? None of that has ever come to pass. And so notice it says in 2019, they added the box, no substituted disclosures for this transfer. And notice it says to accommodate the most common scenario, this is down here, the most common scenario where no substituted disclosures are made, a new option, no substituted disclosures, was added. What is a substituted disclosure? It's something that was intended to satisfy the obligations on the TDS form. Now, it mentions an NHD report, so if you've got one of those, is that a substituted disclosure? And if you read this, the answer is no, right? Because the NHD should not be considered a substituted disclosure for two reasons. One, it isn't intended to cover anything other than natural hazards. And second, you're going to see that there's a separate requirement that the seller do the TDS. Should prior inspections and reports be specified in Section 1 of the TDS? The answer is no. No, because they weren't done to substitute for the seller filling out the TDS. They really weren't. So what is the bottom line? You should probably be checking no substituted disclosures. I've sat through California Association of Realtors legal webinars on this, and I did it. I hope you guys all understand. I did that so you wouldn't have to. Right? I hope you feel sympathy for me. I did it so you wouldn't have to. And basically, you're welcome. And basically, they say you should pretty much always be checking this box here. No substituted disclosures for this transfer. These other additional inspections and reports are not intended to satisfy the disclosure obligations on this form. Did everybody understand? The NHD, your property inspection, your none of those things satisfy the disclosure obligations on this form. None of them do. Now,
Yes.
that doesn't mean you don't give them a copy and you can't make a reference to it. But normally the box you're going to be checking is no substituted disclosures. Now, one of the, of course, ironic things is we're not supposed to fill this out for them. And most of you don't understand what has been going on. Maybe now you do, but most of you, I would bet, didn't understand what that section was about to begin with. What is the chance the seller knows? Right? What's the chance? Probably
Zero.
Zero, right? So you might have to explain that we don't have. What about the property inspection? We're going to give them a copy, but it doesn't substitute for your obligation to answer these questions. All right.
Good.
Buyers may rely on this, and so anyhow, then here's the form, and then what? We can't fill any of this out. Then here it is, and so we put in the name of the seller, right? One seller, and then here is the agent's inspection disclosure. Now, what you probably should be doing, depending upon how I'm going to try and say this without being snarky. This is hard. My filters don't work very well. Let's say you work for a professional, that's a bad way to put it, brokerage, right? Which has, they're going to want to see that first box checked, right? Attached agent's visual inspection disclosure. Now, what if you don't see anything, right? What if it's a relatively brand new home, right? Can you just check agent notes, no items for disclosure, and get on with it? Not at EXP, and by the way, many large companies don't want to see that either. Could we say, just write in a few things here? And the answer is not at EXP. What we want is for you to check the first box. Now, yeah, question?
No, AVID should be noted and attached.
Right, you should always have the AVID. And now your broker, your broker may have a different idea, but I'm just saying, well, what if there's nothing to note? What they want you to do is each room, we're going to get to that in a minute. Right? To say something, so at least we know you've looked at it. So here's the form. Now, the other one, I'm not going to do the SPQ. I mean, the SPQ, why not? Let me just go here. Here's the seller property questionnaire. So if I were doing it, these would be the two forms I would send at once. Notice how when I launch the seller property questionnaire, it's already filled in what I wrote before. Now, this here is this. There is what's called an exempt seller disclosure. And that's if you're on that list. It's a trustee, a successor trust, not a family trust, right? Not an inter vivos trust, right? But somebody died, successor vested trust.
What's the final answer on that? What you're supposed to do if they won't fill it out?
You just leave it blank and you have an email back and forth saying that you told them to fill it out and they wouldn't do it. I've had clients refuse to fill it out.
Does EXP make you do the 3 times thing, or you make 3 attempts?
No, not that I know of.
So what's the main reason the sellers aren't filling it out?
They're investors, they never lived there, and they're afraid that if they give the wrong answer, they're going to be sued. So they decide not to give any answer. All right, since we're on this subject, if the seller doesn't fill it out, does it, and the escrow closes, does that create a legal liability to the seller? Like, are they going to go to jail for violating 1102 of the Civil Code? Will they have to pay a fine?
No.
Can the transaction be rescinded after the fact? And the answer is no.
No.
The answer is no. All right. What if the seller doesn't do this? It means the seller will be in breach of contract. We're going to get to that. Paragraph 10 of the Residential Purchase Agreement. Of course, you guys all know this. Paragraph 10 of the Residential Purchase Agreement gives a list of things the seller is supposed to do. It says seller shall. We're going to look at that in a minute. Right? And one of the things seller shall do is complete a TDS and an SPQ. Which means that you could send them a notice to perform and then they don't perform. But what are you going to do if you represent the buyer? Cancel? This is the thing. They have given you a get out of escrow free card if they won't do this. Does everybody understand that? If the seller won't do this, they've given the buyer a get out of contract free card. And so, but that doesn't mean your buyer wants to get out of the contract. It just means they can. All right. So this is the statutory required disclosures, which you'll see if it's under the exempt seller disclosures. So here are all these different questions. All right. Now, again, you'll see they're all blacked out. Now, if I were going to do this for real, I would go to, and by the way, one of the things that would help, certainly me, if I'm helping you, it would help me, is if you learned how to use zip forms, Lone Wolf Technologies, RPR, the multiple listing service, and what's related to that, RPR, and how to set up templates in zip forms, and how to do e-signatures. It would just make everything happier. So what I'm going to do, in the order in which we touch these is the order in which it'll be included. We're going to do that one, we're going to do that one, and then we're going to just, all right, close. All right, so we've added our 2 documents. Signature package 1, usually I would name it something else. I usually would put in the address of the property. And the reason I like to do that is so that later when I'm looking at all these documents and emails and, it gets complicated. So we're going to do this, and so we have our seller sue, and the only people that are going to be signing this are the seller and the agent. And we hit close, next. And then, if you guys haven't seen this yet, I'm sorry to hear that. But here we go. Now notice, see all these things that they've already filled it out for me. No, those are all the things you can't change. So we're just going to click on next. And I don't mess with custom invitations because I'm too lazy. And away it goes. Now what's going to happen is, in a moment, I'm going to get it. And it may take a second. It may take a second. All right. So while we're doing that, giving it a moment to find itself. Here we go. So here's a copy of an RPA. One of the many we've got going on right now. So what I do say, and by the way, it wouldn't hurt you to take a copy of the residential purchase agreement and print it out, right? Or I use highlighters and things like that involving PDF, whatever makes you happy. And my suggestion is, if you really want to know what this document says, go through, like, let's say with the green highlighter, and you want to find everywhere where it says seller shall, right? Does everybody see that? Everywhere that it says in the RPA, the residential purchase agreement, seller shall, you might want to highlight that, let's just say in green. I don't know why, but green. Now, later when we find things that says buyer shall, you might highlight that in yellow. If you find something that says contingency, highlight that in red. And by the time you're done, you're going to have all the obligations of the buyer and the seller and the contingencies. So this is saying, paragraph 10, seller shall, within the time period of 14A, 7 days, of course you guys knew that, deliver, and it says, unless exempt, fully completed disclosures or requirements required by sections 1102, 1104 of the statutory disclosures. They include, but are not limited to, the transfer disclosure statement, natural hazard disclosure, controlled, and on it goes, if seller has actual knowledge. Then it says in 10A2, any disclosure required by this paragraph is considered fully complete if seller has answered all questions and completed and signed the seller sections, and the seller agent of any has completed and signed the buyer brokerage firm section, or done an AVID. Now, notice what's missing from that paragraph is a reference to the buyer's agent. And it goes on to say that nothing stated herein relieves a buyer's brokerage firm, if any, from the obligation to do an AVID. It's just not part of the contract. Right, and what that means is if the buyer's agent hasn't done an AVID, the contract isn't gone, it isn't thrown out, but the seller's agent and the seller have to do the TDS and the AVID, right? The buyer's agent is supposed to do it because the law says so, and your broker is probably going to require it, but that's not part of the seller shall. Can the buyer waive the transfer disclosure statement? And the answer is no, you cannot waive it. You can't waive lead-based paint disclosures, nor can you waive the natural hazard disclosure.
Sorry to interrupt you. So both the buyer agent and the seller's agent typically fill out that AVID form?
They have their own. They each do their own. Right? And sometimes the agent won't do it except click on notes, no items for disclosure, and turn it in. Right? If you're at a big company, they're going to hassle you. And tell you to go do it. All right. So, buyer shall, it says here, within the time period in 14B1, return signed copies. Now, look at paragraph 6. In the event seller or seller's brokerage firm, prior to close of escrow, becomes aware of any adverse conditions materially affect, or any material inaccuracy in disclosures, information, or representations previously provided to buyer, seller shall promptly provide a subsequent or amended disclosure or notice in writing covering those items. However, it shall not be required for of which the buyer is otherwise aware or which have been disclosed in reports given by the buyer. So what that means is buyer gets a termite inspection and there's fungus, right, under the sink. There's a fungus among us, right, is what the property inspector said. So you give that to the seller. Well, you could argue now the seller knows that there's fungus. Does the seller have to correct the TDS? The answer is no. But if it was something that the seller knew about but just failed to mention and then said, oh yeah, we do have electrical problems with the property, then that would trigger a cancellation right. If any, paragraph 7, if any disclosure or notice specified in 10A or subsequent or amended disclosure or notice is delivered to buyer after the offer is signed, buyer can cancel within 3 days after delivery in person or 5 days after deposit in mail or by an electronic record. So if you email, we rarely are handing these things to the buyer. So if we email a copy of the buyer an amended TDS or SPQ, how long does the buyer have to think about that? If we
3 days.
3
3
days.
days.
Really?
No, is it 5? 3 to 5?
5 days.
5. Let's look at this again. I thought I just read it, but I'll go slowly. Buyer shall have the right to cancel within 3 days after delivery in person. So if we email it to the buyer, did we deliver it to them in person?
No.
Do
Okay, no, so
people
it's 5 days.
do people read their email all the time? Every 15 minutes are people checking their email? Not even real estate agents. Believe me.
Mhm.
Right. Believe me. Some do. Or 5 days after delivery by deposit in mail or by an electronic record satisfying this by written. So anyhow, that email, 5 days.
Mhm.
And by the way, it's repeated, this rule, in 14b3. 14 is time periods.
Mhm.
14b is a buyer time period. Look at 3. By the end of the time in 14b1 or otherwise specified this agreement, buyer shall deliver to seller removal of the applicable contingency or cancellation of this agreement. However, if any report, disclosure, or information for which seller is responsible is not delivered within the time specified, then the buyer has 5 days to either remove the contingency or cancel the contract. 5 days. So if this is why listing agents who know what they're doing want all this done in advance, you can give it to the buyer before they write an offer. Because if you give the TDS and the SPQ to the buyer before the buyer writes the offer, then the buyer has no time to back out.
Mhm.
If you give them the TDS or the SPQ after the offer, they have 5 days, unless you go pound on their door and hand it to them, right? They're going to have 5 days to cancel, right? And if there is an amendment or a change. So I may have told the story before, but I was helping, this wasn't my transaction, but because of my role in the office, things were going bad and they asked me to take over. And the buyer had made an offer, a house in Sunnyvale, no contingencies, no contingencies. But then we get into an argument about the size of the lot. There's discrepancies between what the tax records say and what the prelim says, and the buyer actually goes out to the property and he's an engineer, measures it himself, and confirms that the smaller number is what he believes to be the lot size they want out. They want out, but no contingencies, right? So the agent that this was kicked up to on their side starts going through all of the documents and notices that the seller did not answer all of the TDS or SPQ questions, had left some of them unanswered. What they did is they sent us a notice to perform, quoting that previous clause that says it ain't over until it's over. You have to answer every question. And then if we answer those questions, does that now trigger a cancellation? Does it trigger a cancellation right in the buyer? And the answer was maybe. And they claimed, yes, it does. You've modified it. We're canceling. My argument was the answer to the questions was no. There was no additional negative information communicated. And there's another clause in the contract that says that everybody is supposed to be acting in good faith, and that my argument was that's not good faith. I'm not going to look for the good faith clause right now. That, in other words, if there had been something, where is this? Let's just see. I have way too many emails.
Due diligence.
Let me just see if I can get it here. And I'm not finding here it is. Oh, there it was. So this is what it looks like if you got one of these and you're the seller. Right. I was waiting for this. And then we're going to talk about the AVID. And I'm not going to do the whole SPQ because this is a made-up property. But I just want you to understand, you've sent this to your seller. This is what they're going to see. So they're going to be asked, do you want to change the font, whatever. Just, Notice now the things that are in blue are things that they can mark. You might need to tell them no substituted disclosures. Now notice how it goes through. Seller is or is not occupying the property. So you understand, if you believe that if you're not occupying the property, you don't have to do it, not true. You could check this box and then say, I don't know, right? And then you go through and you check all the boxes. Do you have a security, a gazebo? Yes or no? Right? And then at the bottom, are there any, to the best of your knowledge, not in operating order? Yes or no? And if they say yes, there's some things that are not operating, now they're going to be asked to answer what are they. And by the way, if their explanation goes on too long, it goes on to this other form, which is a text overflow kind of a form. So this is what the seller is going to see. And yes, there are times when I do this when I'm with them or on the phone, because sometimes they don't know. For example, on this list of common, most people have a fence that they share with neighbors. Most people do. Fences, see that? Fences, walls, driveways. Most people share a fence. Sometimes that's the only yes. But is there a homeowner association, right? Is there common areas? It's just asking them questions. And then any lawsuits, right? They should think about this. So let's just say, I'm done. Yeah, okay. Here, it wants me. There's certain things I have to answer. Now, even though the form isn't making me answer everything necessarily, because I didn't check a bunch of boxes up here, I guess that could just mean I don't have any of those things. Where are we? But anyhow, you get the idea, right? I'm not going to finish all this, but there's a lot of stuff to do, and the SPQ looks just like it. All right? Any questions about that? This is easy to do, and what you're going to get, if I do this, do I really want to finish all these? If you do all these, what you're going to get, because I'm on number 2 as the agent, once this is all done, then I'm going to receive from the seller, the seller's TDS with all these boxes and everything checked. Right? I'm not going to really do all that. But then I would have to do my AVID. Right? Speaking of that, let's take a look. What else do I have here? Agent, visual, inspection, disclosure. Is this it? Nah. This is a sample I was going to show you. This is a slide deck from our friends at the California Association of Realtors about how come we have an AVID form. It refers to a Easton versus Strasburger case, which was in Concord, California, back in 1980 is when it all started. And basically, in Easton versus Strasburger, Strasburger was a subdivider, and he sold the property to Mrs. Easton, who the house was built on fill. That's not the name of a guy, but meant the kind of dirt. And there were cracks and all sorts of things. Doors and windows were sticking. And so they found the real estate agent and the subdivider seller both liable, equally, jointly and severally liable. The subdivider had gone broke. The real estate agent had errors and omissions insurance, which ended up paying the entire cost of the judgment. And so, as a result of Easton versus Strasburger, the California Association of Realtors lobbied the state of California to pass the transfer disclosure law. And that way it was the seller has this duty, the broker has that duty, and they're not the same. So what is your duty as a real estate agent? It's to conduct a competent, reasonably competent, and diligent visual inspection. And so there are certain sections. I put this here for your, we're going to go and look at one, and I'm going to show you one that I liked. But notice, no offsite. Do you have to talk about noisy neighbors or things like that? Not necessarily, right? Unless, you know, the seller, you're not supposed to be off-site, right? I guess if you could hear the neighbors. No public records, no common areas. I get asked this a lot. What about the common areas? Do I have to look? No. Do I have to climb up the chimney? Sometimes I say yes just because I'm irritated, but no, you don't have to do that. You don't have to look under rugs or behind closed doors. Yeah. So you could take a look at this. Odors, sounds, any known material defect. And so there's some, I'm going to go through some examples. But don't speculate. So these are some good examples. You're not supposed to diagnose. You're just supposed to describe. I've seen things that said sloping floor indicates foundation issues. And I'm wondering, how do you know that as a real estate agent, right? How do you know that there's a foundation issue? Did you inspect the foundation? Right? You understand sloping floor is good enough. Right? You don't have to give a diagnosis. Water stains in the ceiling because of roof leaks. How do you know that the water stains are because of a leak? How do you know that? Well, why else would they be there? That your job is not to diagnose why there's an issue, simply to describe it, right? If you said mold, I see agents say there's mold, mildew. Did you do a test? You sure it's not fungus? Do you know the difference between mold and fungus? What do you understand? We don't want, again, if we're saying that, I hear some noises in the background. If you're saying that, you're giving them a diagnosis. So uneven floor, you could say that. Cracks in the floor. The 15-degree sloping floor indicated of shifting slab, no. But you could, you don't say caused by earthquakes, you don't do that. So let's take a look. There's a guide, by the way, which I think I've given you. I think it's in your material. I think I put it in here. But there's a guide on the visual inspection disclosures. But let's look at one. And I thought what would be fun is to show you one. Oops, that's not it, obviously. To show you one. And I've blocked out names and things like that to protect the guilty or innocent. I see a lot of AVIDs and things like that. Some good, some not so good. Let me just talk about how you do this. So, your client went to an open house without you, calls you up and says, hey, we really like this house, we want to write an offer. You're like, cool. So we want to have this, you type it all up, shoot it off to the listing agent. Listing agent says, looks good, accepted. Now, everybody starts to collect the documents. And one of the documents people are going to be asking you for is your AVID. You have not seen the property yet. Does that mean you don't have to do it? Maybe you should go look at it. Right? How about that? Maybe you should go look at it. Now,
That's right.
the law assumes you're going to go look at it. What if they they went to an open house 3 hours away, and you don't want to go that far, and so you told them just go to the open house and you'd write the offer? You are supposed to go look at the property. Just saying, right? You're supposed to go look at the property. Now, I blocked out the city and names and things like that just because I hope I got them all. I just wanted to show you, because this one was done, I thought, reasonably well, right? And I wrote an offer on this property, and it gives the, notice it, I took out the name of the brokerage, it was there. Notice it says if this property is a duplex, triplex, fourplex, this is for unit number 1. If it's a duplex, you should have 2. If it's a fourplex, you should have 4. But, you know, put in is it warm, sunny? What does that matter? Well, if it's raining, whatever, right? You know, you would mention that. Not, you know, it might prevent you. Other persons present, that could be the buyers. Except if we're doing, so I'm just saying that if we're doing this for the seller, we're the listing agent. Let me keep my scenario straight. Then the seller might be there. Oftentimes, nobody. Now, the thing I liked about this agent, and I have to admit, this is a fixer-upper. This is a tear-down, right? In a slum area of Santa Clara County called Monte Sereno. And the house was like $3.5 million, the property. Did I mention that this was a teardown? Right, this was a $3.5 million teardown. Yeah, welcome to Monte Sereno. But so there's a lot of stuff on this one that you might not have. If you have a relatively new home, you're not going to have so much to work with. But look at entry. Front door is scratched, cracks in the tile entry. Notice that the listing agent didn't say small scratch, normal wear and tear scratches. Didn't say minor cracks in the tile, normal cracks, normal minor. Notice the lack of adjectives, right? The door is scratched. There are cracks in the entry. Living room, scrapes, scratches on floors, wallpaper is stained and split. It was. I told you it was a teardown. Wood floors are worn, scratched, and discolored. Window is stained. Again, notice none of the adjectives. Cabinets have loose doors and scrapes, dents and peeling paint. Grout is missing and discolored. Chips and dislocation and kitchen sink floors are worn. Notice again, none of the adjectives. Right, and I'm not going to, I gave you a copy of this, but you can see this is what a thorough AVID looks like. Right? This is what it looks like. So the bathrooms, notice he's explaining which one it is, the hall bath, the master or primary bath. Slate floors are stained, laundry room, chips are missing, breezeway, door is not level. Latch does not work. Pool fences in disarray. I told you it was a terrible house. 3.5 teardown. Just, you know. Concrete floor, exterior, you get the idea. Right? So if you wanted to know what a complete TDS SPQ looked like, that would be, you know, what it looks like. So let me ask you some questions. Should you say in the transfer disclosure statement that you're in your AVID as an agent, should you say in it things like buyer is encouraged to get a property inspection? Does that sound like something that is? How,
No.
no.
Mm-mm.
How about this?
No,
I've seen
the wrong place to put it.
I've seen this a lot. Agents type in, "I am not a property inspector," and they put that in the AVID. No. If there's nothing there, say nothing noted. And by the way, there's differences of opinion about that, but I always say nothing noted, and our brokers at EXP want you to say nothing noted. Why do we say nothing noted if there's nothing to note? Because it at least indicates that we looked at the room. We looked at the room. Now, what is the legal liability if you mess this up? And the answer sort of is it depends. Now, and by the way, when I list a property, unless it's a tear down, right, and even that other one, they'd gotten a termite inspection, even though I'm not sure why, because we didn't really want to know how many termites we were going to kill when we tore the building down. But I've had properties that I've listed that were a tear down, and so you don't get property inspections and termite inspections and things like that because you're expecting the buyer to tear it down. But if it's not a tear down, and you're representing the seller as a listing agent, you really, really, really want the seller to get a termite inspection and a property inspection. And I always explain to the seller that if we don't do that, it makes it harder for the buyer to make a non-contingent offer. And we want the buyer to make a non-contingent offer, but if we don't have the inspections, then the buyer's going to pay for them. That's, I guess, good news to you as the seller. But the problem is it's going to give the buyer the right to renegotiate the contract in the middle of escrow. Because when they find out things that are wrong, they're going to come back and ask you to either fix it or to give them a credit or to lower the price, or they're going to cancel the agreement. But if we go ahead and we get a termite in a property and do all that in advance, and by the way, it's a good idea if it says in the property inspection there's something wrong with this electrical panel, you should have an electrician look at it. And it says in the property inspection that there is a plumbing leak and you should have a plumber look at it, and that sort of stuff, that you get a contractor out there to look at those things. I'm talking about the seller and the listing agent before we put it on the market. You get a contractor out there to look at those things and give you a bid as to what it will cost to fix it. And either you get it fixed or you include all this in your disclosure package. Why are we doing that? Two reasons. One, if we've done all of those disclosures and inspections and reports and we get it together, now we're in a position where the buyer can make an offer without inspection as a contingency. That's one big advantage. We don't have to argue about repairs. The two most common reasons, in fact, pretty much the only two reasons, but the two most common reasons why an escrow does not close is, number one, arguing over repairs, or number two, problems with the buyer's financing. Right? And although we're going to do what we can to make sure the buyer can really get, the loan and talk to the loan agent, we can eliminate number one by getting all these inspections and reports. There's an added benefit to you as the agent if you do this, because liability for failure to disclose isn't exclusive to you, but it's like a group thing. What I mean by that is, let's say you missed something that you shouldn't have missed when you did your AVID. Chances are very good the property inspector saw it. Pretty good, I would say. The property inspector saw it, took a picture of it, and wrote about it. And as long as that was done and that was given to the buyer, now you've disclosed that defect to the buyer. And remember, I quoted that clause from the purchase agreement that says that even though that's new information to the seller doesn't have to revise the TDS or the SPQ. It's just new information that the buyer has learned, and that means that if you have a TDS and SPQ, all the reports and inspections and everything done in advance, the chances that you're going to end up meeting lawyers, being in litigation over the property, have dropped dramatically because you've done all of the inspections and the disclosures. Right, so it protects you as an agent. I've double-ended a lot of transactions. I think I double-ended 2 of them last year. I'm not against it. If I'm representing the buyer and the seller, I will make sure that a property inspection, a termite inspection, if they need other inspections, all those inspections are done. Because the biggest problem that agents have when they're representing both sides of the transaction is the failure to disclose a material fact. And you probably do not want everything to hinge on your reasonably competent visual inspection of the property. You're going to want a property inspector, a roof inspector, and a termite inspector to look at the property. Right? And go through all of those inspections with the buyer and make sure that the buyer doesn't want one of them that you don't have. All right. So I put in some guides. There's a quick guide on the seller property questionnaire. And basically it's required everywhere that the other one is, the TDS. What is this? A summary. I've given you a little bit longer for those of you that don't have a social life and want to read more about it. But, if you're part of my group, I want to make sure you understand the process. One final thing. Let's say this is how I would do the AVID. When you're showing property, that might be a good time to take notes, right? While the buyer is walking around, either the real estate agent is walking in front of them and saying things like, here's the kitchen, right? Isn't that a useful thing for an agent to point out to their buyer? Here's the kitchen.
Yes, because they might miss it.
They might miss it. And then the buyers, of course, are thinking, wow, I understand why you need a license to do this, Yeah. And then, a little bit later, you're like, here's the primary bedroom, and they're thinking, boy, I'll bet he really scored high on his test. So,
honestly, like I tell my buyers, we're seeing so many homes right now that I say, take pictures and take video because you're going to forget. And I did have one client that she forgot. She confused the bathroom with a different bathroom and she thought it was remodeled in the one. And I said, oh, it's not good.
See,
yeah.
That's good advice. My advice is you should be doing the same thing.
That's true. And I do that before the walkthrough. I do that.
What I'm saying is to do your AVID. So either you make the notes when you're showing the property, or you go back and look at the property, or you copy what the listing agent wrote on their AVID, throwing in a few lines from the property inspection. Of these options, which one do you think is the best option? I already blurted out at once. My suggestion is, and I see agents in the old school, they would actually bring a copy of the form and be writing on it, right? I have other ways of communicating that. What I'm saying is when you're showing the property, particularly if it looks like one your client may want to make an offer on, while you're showing the property, why don't you take some notes? Would your client expect you to be paying attention to the properties they're looking at and maybe you finding some things that they might have missed?
Good idea.
Right. And so you're already there. I've seen agents drive for hours to go back to the property so they could do their AVID because they didn't write down anything. And just like the buyers, everything was like, pouring water in a full cup. And by the end of the day, they couldn't remember what that property really looked like. And now they're trying to reconstruct the AVID, write one, right, when they don't really remember anything about the property. So I sometimes just take pictures. You can take voice notes. Mine even lets you write with a stylus if you felt like it. You understand what I'm saying? You might want to take the notes while you're there, showing the property, so you don't have to go back or cheat and make it up. I know none of you would ever do that. But
I got a question for you. If they waive the contingencies going into the offer, and then make an offer, and then they give you the transfer disclosure statement, and it has a bunch of bad news on it, do they still have 3 to 5 days to cancel?
5 days, yes. Yes. As it says in paragraph 10 of the residential purchase agreement, which is simply stating what the law says, 3 things that are common in a real estate transaction cannot be waived. 3. One of them is the TDS, and I'm putting the SPQ with it. The Civil Code doesn't mention the SPQ. Statutorily, the contract does, but the law doesn't. But the TDS, the natural hazard disclosure, and the disclosure of lead-based paint, the booklet and all that, those cannot be waived. And the 2 big, so if you don't, if this is why you want an NHD report as part of your package if you list a house. Because if you give it to the buyer afterwards, they're going to find something wrong if they want to. There's environmental things, there's something. Oh my God, there's liquefaction. You know, I want out. So if you give, and there's no way for them to waive that. So an offer without contingencies means there are no contractual contingencies. But that does not supersede what Section 1102 of the Civil Code says. Right? Doesn't override it. The buyer cannot waive the TDS requirement for the seller. Can't waive it. Okay? Can't. And you understand if they don't answer all the questions and you force them to answer the questions and one of their answers is not a happy answer, you can back out because they've now modified or made further disclosures.
What's the cancellation? Is it 3 or 5 days for the natural hazard disclosure?
5 days.
Okay.
Yeah. All right. 5 days. And I think it's 10 days for the lead-based paint, but people don't really, that one never doesn't come up as much. You know, because basically it says we don't know if there's lead-based paint and we've never had it tested, and you can have it tested if you want to.
On the TDS SPQ to be provided.
Say that again. TDS SPQ what?
And to be provided to buyer.
Right. What it says in paragraph 10, if the buyer is given a copy of the TDS and the SPQ prior to writing the offer, then the buyer's offer is assumed to have incorporated that knowledge, and there is no 5-day, 3-day right of rescission anymore. So do you understand? You better read that and have your buyer read it before they write the offer.
They could just say if they change their mind, they could just blame it on one of those 3 things, right?
Right.
That'd be okay.
There's a clause in the contract that says it has to be in good faith. Like the case where they forced us to answer questions, but the answers were no, so there was no negative information disclosed. I believe I have a good argument if we went to arbitration that was not canceled in good faith. They were really canceling because of the lot, and they were using that as a way of doing it, right? However, it would be much better. This is why having a good transaction coordinator is important, because somebody needs to look at these forms and see, did they miss any questions? Because if your seller missed a question on the TDS or SPQ, we need to fix it, right? Because later that could become an escape hatch for the buyer.
Can I ask you a quick question,
Yeah.
Mike? If you're representing the seller, when's the best time to do your TDS? Especially, I'm representing 2 Apple employees. They work from home. They're very persnickety about who goes into our house. They need at least 3 days notice, blah, blah, blah. So I thought I was going to do it the weekend of the open house.
Your AVID, you mean?
Yes.
Yeah.
Sorry.
Yeah, that's fine. You just need to know that there's a 7-day requirement to turn over those things once you're in contract. I mean, the short answer is if you get into if you do it before you're in contract, and you can get it in the disclosure package, it doesn't matter. In a sense, the AVID doesn't matter if there are all the other inspections and reports. Because chances are they've done more disclosing as a result of that.
Right.
Than what you would notice. And It's if you do not have inspections and reports, and it's not a tear down, and you're not dealing with a sophisticated buyer, now all of a sudden this becomes important because you're the only expert. Oh my God, that's looking at the property and giving recommendations.
Right. Okay.
Using the word expert, fanciful way. Right?
So if the seller amends the TDS, do they have to fill it all the way out again, or do they just amend the portions that they're amending?
What they do is they fill it out again, and what you do, and I'll use this as an example. What you're supposed to do is write on top of it that it's been amended.
So like amendment number 1,
Right.
First Amendment.
Now, the form isn't designed to do this. It's not. One of the classes I'm planning on doing in a little while, there are all the little extensions and things that you might want to use. I use something called DocHub. And what DocHub would allow me to do, this is a free program, right? What it would allow me to do, notice I'm looking at it right now, and I can type in
You're not sharing the
Can't
screen.
see your
I'm
screen.
sorry about that.
Yeah.
How about that? I thought you missed me. So DocHub, when I open up this document, I have, because I've installed DocHub, a choice that you may not have, right? And what DocHub allows me to do, see all these wonderful things here, it allows me to type on the PD, this is a PDF form, right? And I can move it around, and I could change the font color, I can change the font size, right? I could do something like that. And unless the California Association of Realtors legal department says you should write the words amended on the top of the form and redo it. That's what they say. Of course, they don't explain how you're supposed to do that if it's a PDF. Well, anyhow, that's how we do it. All right? So I've given you one of my programs, DocHub. It does other fun things, which we'll cover in a different class. Well, we've gone on a little bit long, which is unfortunately common for me. So I hope you found this valuable or helpful. If you guys are interested, if you're in my group and we haven't talked in a while, make an appointment. If you would like to be in my group because you want to make more money and you'd like things to go easier, reach out to me because I'd love to talk to you about it. Everybody stay safe out there. Have a good day. Bye.
Thank you.
Thank you.